I'm Dr. Kalpana. In this lecture, we would be dealing with the topic regulation of conditions of service and managerial prerogatives. This presentation explores the legal framework governing employment conditions and managerial authority in industry setting. We would be exploring the significance of industrial standing orders, requirement for notice of change in service conditions, and protections afforded to workmen during industrial disputes. Understanding these regulations is important for ensuring fairness, stability, and accountability in the workplace. Now, coming to industrial standing orders, what are the meaning and purpose? Industrial standing orders are written rules that standardize employment conditions covering aspects like working hours, leave, and disciplinary actions. Uh, their objective is to ensure transparency and uniformity in service terms between employer and workmen. Governing law, Industrial Employment Standing Order Act 1946 applies to industrial establishment with 100 plus or more workmen. It mandates the employer to draft, certify, and prominently display these orders. Certification procedure: employers submit a draft which is then served to trade unions or workmen for review. After hearing, the certifying officer certifies the orders, ensuring they cover all matters listed in the Act schedule. Managerial prerogative: once certified, standing orders become statutory terms of service, overriding any inconsistent service rule or appointment letter as affirmed in Bagalkot Cement Company Limited versus R.K. Pathan case. Notice of change in service conditions. Section 9 of Industrial Dispute Act 1947, employers are prohibited from unilaterally changing service conditions related to matters in force schedule without providing 21 days prior notice to the workmen. For schedule examples, this includes change to wages, bonus, working hours, leave, shift timings, demotion, transfer, rationalization, or introduction of new technology. The purpose provision aims to prevent abrupt changes that affect workers' livelihood, thereby ensuring industrial peace and stability. Case law and exception as seen in Express Newspaper Limited versus Workers in 1963, altering wage structures without notice is invalid. Exceptions include changes by mutual agreement or limited administrative necessity. Protection during industrial dispute. Section 33 of Industrial Dispute Act. During conciliation, adjudication, or arbitration, employers are restricted from altering service conditions to detriment of workmen. Workmen concerned in dispute: for workmen directly involved, no changes can be made without prior permission from the authority overseeing the proceedings under Section 33, Subclause 1 of Industrial Dispute Act. Other workmen and disciplinary actions: changes for other workmen must not relate to dispute. Under Section 33, Subclause 2, for disciplinary action like dismissal, employer must conduct an inquiry, pay 1 month wage, and seek approval from the authority as per Section 33, Subclause 2b. Maintaining status quo. Case law such as Punjab National Bank versus All India Bank Employees Federation 1960 emphasizes that Section 33 aims to maintain the status quo. prevent victimization during disputes. Now, to conclude this lecture, standing orders, these orders form the bedrock for clear and lawful service conditions, ensuring transparency, standardization in employment terms. Section 9A, this provision acts as a vital safeguard against arbitrary managerial decisions requiring prior notice for significant changes in service conditions. Section 33, this section offers crucial protection to workmen, shielding them from victimization and retaliation while industrial disputes are ongoing. Collectively, these legal provisions establish a robust framework that promotes fairness, stability, procedural accountability in industrial relations while also carefully balancing managerial prerogatives with employees' rights. With this, I would end here. Happy learning.